Hey everybody, how you doing? It's good to see you. Well, I can't actually see you. This is YouTube. Figuratively speaking, though, it's good to see you. It is September 2021. It is the beginning of the 2021-22 debate season, and we're kicking it off in Lincoln Douglas debate with the resolution resolved. The member nations of the World Trade Organization ought to reduce intellectual property protections for medicines. If you are new to the channel, first of all, welcome. A little bit about us very briefly. Hail State Debate is created by the Mississippi State University debate team. The basic idea is that we want debate to be accessible to everyone. So we create what I hope is a high quality resource on every new LD and PF topic. My name is Brett Harvey. I'm the coach of the team. We frequently have team members on the videos, but because it's the beginning of the year, I'm having to fly solo on these. And the basic goal of the channel is to sort of balance technical understanding of how debate works and how the debate community works with real world argumentation. In other words, arguments that can stand up to scrutiny in the real world, right? Because we want it to be useful to you, our timestamps for the different sections and the links to all the sources we cite will be below in the description. If it is useful, maybe like, maybe subscribe, maybe tell a friend. And if you want to follow sort of our general musings on like life and debate and when we just like crack jokes about stuff, you can follow us on Twitter at Hail State Debate. So we've got a lot to cover today. I'm glad you were debaters so I can talk a little bit faster. I'm going to start with two general observations about the topics for the initial thoughts, and then we'll move on to the different sections of the video. So two thoughts. First of all, the subject matter area of this resolution is great, but the wording is really kind of weird and less than ideal. Now we know what the NSDA was generally getting at here, right? Should we waive patents for the COVID vaccine and treatments to help poor countries, right? Developing countries like India and South Africa have petitioned the WTO to waive certain provisions of an international treaty, the Agreement on Trade-Related Aspects of Intellectual Property, or the TRIPS agreement, right? To waive its requirements that countries enforce their IP or intellectual property protections for COVID drugs and vaccines, right? So the idea behind the proposal is to make these drugs more accessible in the developing world, because when you take away intellectual property protections, that removes this exclusive monopoly right that the patent owner has to make the drug, and allows pretty much any drug manufacturer to take that patented treatment or vaccine and to make a version of it and to charge dramatically less for it, right? And so what NSDA almost certainly had in mind in writing this topic was basically, should we do something like that? The problem is the wording of the resolution is kind of trapped between two worlds. It can't decide whether it wants to be a general value-oriented resolution or a highly specific policy resolution, and it kind of fails a little bit at both, right? So if you wanted a clean value-oriented resolution, you could have said something like, resolved in a pandemic, suspension of intellectual property rights on medicines is justified. And then you could just focus on the moral question without worrying about like the details of international law. Or if you wanted a more direct policy focus, you could have done something very specific, like say, resolved World Trade Organization member states should waive the TRIPS agreement protections for COVID treatments and vaccines, right? You could do either one. But NSDA didn't do either one. Instead, it did this kind of like halfway in the middle approach where it starts out specifically referring to WTO, World Trade Organization members, but then it transitions to this vague sort of mealy-mouthed wording about like reducing intellectual property protections. And then rather than specifying the one set of drugs and treatments we're actually probably debating about, at least the one we think they intended, COVID treatments, right? It uses the super vague term medicines, right? And the bottom line is, if you didn't know better, you could easily read this resolution and think it was about like IP, intellectual property reform in general, right? Like maybe eliminating practices that extend patent terms for medicines in general, as opposed to taking a very specific action in relation to COVID vaccines. But now, at the end of the day, I want to be clear. A careful reading of the resolution leads me to conclude that waiving WTO agreement provisions that mandate IP protections for COVID vaccines and treatments is indeed the correct interpretation of this resolution. But the fact that it took me like a full day of research and careful reading to conclude that, and the fact that some debaters could easily look at this resolution and be confused and come in talking about like drug patent reform in general, indicates that this is a good topic area, but a poorly worded resolution. Second basic point in terms of initial thoughts is that there are a lot of background concepts you need to understand on this topic. Even when you slim the topic down to just COVID drug patents, which I think is appropriate, there are a lot of underlying concepts that are not going to be intuitive to most typical judges, most lay people that you'll see in many circuits, right? The first is intellectual property in general and the incentives and trade-offs that it creates, right? The second is pharmaceutical development and the economics and incentives that go into that, right? The third is getting a basic grasp of the specific regulatory and legal regimes that govern IP protections for drugs. And that involves understanding both international agreements like the TRIPS agreement that govern intellectual property, but also the basics of how individual countries grant and protect patent rights, at least a little bit of that, right? And the fourth is exactly how we would go about reducing IP protections. As I said earlier, what we're going to focus on in this video, what I think the correct approach is current existing proposals before the World Trade Organization to waive provisions of the TRIPS agreement that protect patent rights, okay? But anyway, that's a lot, right? That's a ton. And as with any complex topic, good debaters are going to want to develop a deep understanding of these issues that goes beyond just, what you write in your case, right? You're going to have to be able to explain how the concepts work in cross-examination, in rebuttal. So if you can't, for example, logically explain how the incentive structure of intellectual property works on a basic level, well, you're going to need to sit there and read and talk with your coach and your teammates until you can, right? Anyway, as you can see, there's a lot to cover here. So I think it's best to jump right in first with a fairly detailed review of background information and concepts, then definitions and framework, then the aff, then the neg, and then some final thoughts. Okay, so let's talk about some key background information on the topic. Like I said earlier, there's a lot to cover here. I mean, a lot. So I'm going to divide it up into 5 key questions and basically try to answer each one as efficiently as I can. So let's just go in order and start with the first one. Question 1, why do we have intellectual property laws at all? You can start with the Stanford Encyclopedia of Philosophy's entry on intellectual property. Does a really good job of explaining IP. Again, IP is just, the sort of abbreviation for intellectual property. From a more philosophical, LD-friendly perspective, it's a good read to sort of get your feet under you from a philosophical perspective on IP. The basic notion behind intellectual property protection, or IP protection, or IP rights, or IPR, sometimes we see it abbreviated that way, but it's basically very simple. When a person makes or builds a physical object, they own and control it in a physical sense, and thus they can use it, sell it, or trade it as they like. So for example, if I am a master craftsman and I build this really beautiful table out of wood from a tree that I cut down, well, I can do whatever I want with that table. I can put it in my house, I can sell it to somebody else for whatever they'll pay for it, right? But what if I make something where most of the value isn't in the physical parts or even in the labor that it took to put them together, but in the idea behind the object? So instead of a table, let's say I invent this really efficient new electric battery, right? Well, I can use that particular battery in my car, or I could sell it to somebody else for whatever they'll pay for it, right? But once I've sold it, I lose control of my idea, right? And it may be an idea that I've worked on for years and invested a ton of money into. But once you buy my electric battery, well, you can take it apart, figure out how I made it, copy it, sell it to other people. If there's no intellectual property laws, that's what you can do, right? And I don't get a dime from that. So intellectual property is just the idea that the law should give me, as the creator, in this case the inventor, some ability to keep you from doing that. That I should have some ability to control my idea, whether it's a battery or a new kind of drug or a song or a novel. And just as importantly, I should be able to profit from it, and I should be able to keep you from profiting from it, like at least for a certain period of time. In other words, intellectual property laws, generally speaking, give the creator, whether it's a person or a company, a temporary monopoly on controlling their creation so that they and they alone can profit from it. Now, because this is LD debate, it's worth noting that there are different justifications that philosophers and economists give for why we should recognize intellectual property rights. Adherents of like John Locke, say, for example, might argue that you have a natural right to make use of the fruits of your labor. You work to create something and you inherently have the right to control what you made. And it doesn't matter whether it's a table or a new battery or a drug or a novel, right? You have that right. But the far more common justification for IP rights in the modern world is utilitarian. In other words, if we want inventors to invent new things to make our lives better, we have to give them proper incentive to invest their time and their resources and to take the risk, because many inventions, including many drugs, don't pan out at all. They're not commercially viable. And the way that we do that is to give them intellectual property rights so that they and they alone can make lots of money on their idea if it proves to be useful to society. Now, there are several basic types of IP protection. Copyrights, trademarks, patents, and trade secrets are the big ones. Copyrights are in creative works like movies, music, and books. Trademarks are symbols used to identify a business like the McDonald's arches or the names of companies like Facebook, Amazon, and Walmart. Trade secrets are things like secret formulas that may not be patented, but they are kept secret by their owners. And trade secrets do come up a little bit when we talk about IP protections for drug makers. But the main type of IP protections that we're going to be concerned about, primarily on this resolution, is patents. Patents give you a time-limited monopoly over some kind of useful invention. And for the lifetime of the patent, only you as the owner can manufacture and sell whatever the patent covers. Or you could license the patent to someone else and let them make something, but you're going to make them pay you for it, right? So either way, for a successful invention, if it's patented, you can make a lot of money. Right, but this monopoly right that a patent confers is a deal with an upside and a downside for society. On the upside, by giving inventors the ability to reap massive profits, we hope to encourage the creation of many new inventions, including drugs, to make people's lives better. But on the downside, granting the patent holder a monopoly means that for the lifetime of the patent, there will be no market competition. Generally speaking, nobody else can manufacture the drug, which means the patent holder can charge the absolute maximum that people are willing to pay. And this is why you see astronomical prices for certain prescription drugs, in some cases costing tens of thousands of dollars for a single course of treatment. And it's why you hear horror stories of terrible people like Martin Shkreli buying up patents for drugs that treat rare diseases and then jacking up the price 3,000%. And because this trade-off is so significant, and consumers pay so much more for patented products, right? Patents tend to have significantly shorter time limits than other types of IP protection. So in the US, copyrights for things like movies and music can last for 70 years or more. Trademarks for brand names and logos can last forever, but patents under US law are supposed to last just 20 years, right? When it comes to drugs specifically, the core deal that we are making through IP protections is this. We're going to give you a monopoly on the drug that you've created, and we're going to let you, if it's successful, make a fortune on it for about 20 years, and then after that, it's fair game, right? Anybody can manufacture it. In the drug context, we call this generic versions of the drug. In other words, what we're going to do basically under IP is we're going to incentivize the production of new medical technology over the long run by letting you charge way more than the market would allow and make a killing on it, no pun intended, in the short run. Which leads to question 2. How does IP protection affect production and distribution of drugs and medicines? Well, this incentive structure, right, this deal that we've talked about in the IP world is particularly important in the context of drug development because new medicines aren't generally created anymore, at least, by passionate individual inventors who just want to help the world and aren't concerned with money. They are created by big pharmaceutical companies like Pfizer and Merck and Johnson & Johnson to make a profit. These are multi-billion-dollar corporations that invest hundreds of millions or billions of dollars into researching and testing potential new drugs in the hope that some of these drugs will be massively profitable for them, right? And to give the devil their due, pharmaceutical research isn't free. It's extremely expensive and it's extremely risky. You can dump tons of money into a potential drug only to find out it doesn't work or the FDA won't approve it. For example, Merck spent a lot of money trying to develop its own COVID vaccine and then realized it was way behind in the race and it just gave up. And all the money it spent was for nothing. It was just lost, right? So pharmaceutical companies will tell you that for every big winner drug they find, they have tons of money losing drugs, and they need these strong patent protections that let them charge huge amounts of money for a long time when they do hit the lottery on a profitable drug so they can make up the losses and keep the research and development machine running. So 2 of the big meta questions that you're going to see in this debate or any debate about drug prices or drug availability is if we reduce intellectual property protections for, say, COVID vaccines and treatments, presumably by waiving patent rights, as we're going to talk about in a minute, how much will that improve access and affordability in the present tense, like right now, versus how much will it reduce the incentive to create new drugs in the future and thereby reduce the flow of beneficial new medicines down the road, right? That is an intensely complex empirical and theoretical question. There is a metric ton of research on how the pharmaceutical industry runs and how much profit and by extension how much IP protection it really needs to make this research and innovation happen. Unfortunately, we don't have time to dive deep into the economics of drug company research and development and incentives. But luckily, if you want to learn more about it, we actually have a video from several years back from the PF debate topic on drug price controls. And we will put a link to that video below low. So if you want to do a deeper dive into the economics of like how much profit does it take to get these drug companies to go in and research and come up with these great new drugs, you can actually watch that video. That leads us to question 3. What does the World Trade Organization have to do with any of this? Why has the NSDA specified the member nations of the World Trade Organization, presumably as the actor here? Well, if you think about it, IP protection is one of those areas where international agreements are really essential, right? If you live in the United States and US laws protect your patent, but say Mexico does not, well, then someone could just take your invention, whether it's a piece of software, an electric engine, a drug, whatever, down to Mexico, manufacture copies there, and from there, those copies could spread all over the world, legally or illegally, maybe even back into the United States, and it would greatly undermine your ability to profit from your invention. So it's really important for countries, particularly the countries that are major producers of new intellectual property, to agree on some basic rules for IP protection, because otherwise, like a single rogue country or a handful of countries with weak or non-existent intellectual property laws could conceivably undermine the whole system of incentives. And by the way, this idea is not new. Countries have been discussing international IP rules since the 19th century, when the Paris Convention for the Protection of Industrial Property was first adopted in 1883, which happened, by the way, partly because inventors were reluctant to show their inventions at international expos like the World's Fair because they were afraid that somebody would see it and make a copy of it and make a knockoff and they'd lose their profit. So ideally, in the modern world, you would want some kind of international body to help implement and enforce an agreement about IP protection. And wouldn't you know it, the WTO, the World Trade Organization, fits nicely into that role. The WTO is a voluntary intergovernmental organization established in 1995, currently has 164 member countries representing about 96% of global trade. Countries want to be part of the WTO because the most basic rule in the WTO is once you're a member, every other member has to extend you most favored nation status. In other words, in terms of things like tariffs and other barriers to trade, they have to give you the same good deal as they give to their favorite trading partners, which, as you can imagine, is a huge incentive to be part of the WTO, which is why every major country is, right? But with those privileges come lots of rules. Member countries are all parties to dozens of different agreements on many different aspects of trade, from agricultural restrictions to restrictions on export subsidies to basic food safety rules. And unlike past piecemeal trade agreements on intellectual property, these WTO agreements are a package deal. You do not get to pick and choose which ones you want. If you are a member, you have to follow them all. And one of those agreements in particular, and the one that is super important for this debate topic, is, as we said, the Agreement on Trade-Related Aspects of Intellectual Property Rights, or TRIPS. Now, we're going to show you a couple of good summaries of TRIPS from the U.S. Patent and Trademark Office and from the WTO itself, as well as a link to the TRIPS text itself if you actually want to read that. But a really brief summary is that TRIPS became effective back in 1995 as part of the agreement establishing the World Trade Organization. So this is one of the OG treaties, right? It was there since the very beginning. And what TRIPS does is it establishes minimum standards for the availability, scope, and use of various forms of IP protection, including copyrights, trademarks, trade secrets, and most relevant for our purposes, patents, right? Pharmaceuticals are just one type, albeit a very important type, of the intellectual property covered. But under TRIPS, the global baseline for patent protection is this. Number one, you have to grant patents to all types of inventions with a few exceptions. Number two, you have to not discriminate between foreign and domestic patent applications. You can't treat your own citizens better than applicants who are from another country. And lastly, you have to protect the patent holder's exclusive right for at least 20 years from the application date. So basically, TRIPS says you must protect patents. That's really important. That's the takeaway here, right? However, TRIPS also provides for significant exceptions to these patent protections. And these are very important to understand because, as we're going to talk about later, they can allow the negative to argue that we actually don't need to reduce IP protections. We don't need to waive patent rights because the status quo already provides mechanisms to ensure the ready supply of COVID vaccines and treatments. So let's talk about the exceptions that are built into the TRIPS agreement. The first is an outright exemption from drug patents, period, for developing countries, right? It's important to note that TRIPS's drug patent requirement was phased in over time, and the phase-in time was based on a country's level of development. And we're going to link to a summary of exactly how that happened, but in a nutshell, the date you have to have your drug patent laws in place was based on how developed you are as a country. Least developed countries, or LDCs, were originally scheduled to be required to have drug patent protection by 2006, but that has been extended several times and is now not set to take effect until January 1st of 2033. So who are these LDCs? Well, they're designated by the UN, but there are places like Afghanistan, Sudan, and Haiti. They are the poorest of the poor countries, but they do encompass about 800 million people. So this is a very important exception to the general rule that drug patents are required. Countries that, for example, actually currently have no patent protection for drugs include, but are not limited to, Angola, Madagascar, Liberia, Rwanda, and Uganda. So there are WTO members that have no drug patent protection and are not required to, at least not until 2033, right? Now, there are other exceptions beyond that. Second, for example, patents can be denied or prohibited for reasons of public order or morality. That's probably not really relevant to drugs in most cases. It probably has to do with things that are, considered immoral or unacceptable. Third, there is the exception for compulsory licenses and waiver of import restrictions on patents, including drug patents. And this is probably the single most important exception for purposes of this debate. And you really need to understand this exception for compulsory licenses. Countries can impose what are called compulsory licenses by which a patent holder is forced to let another manufacturer make their product. In other words, the government can say, hey, patent holder, we are ordering you to allow this other company to manufacture your drug after they make some kind of payment to you, but we as the government get to decide how much that payment has to be, right? Now, normally these compulsory licenses under the TRIPS agreement have to follow strict procedures, and they actually have to pay the patent holder the market value of the patent. But in, quote, situations of national emergency or other circumstances of extreme urgency, these requirements can be waived under the TRIPS agreement. And this is Article 31 of the TRIPS agreement, and we will link to the actual text of that because it's important. But what this means is that in a national emergency, and I would certainly think COVID qualifies as a national emergency, a government can take a drug patented by company A and grant this compulsory license to companies B, C, and D to manufacture it. And what's more, the government can set the terms of this license, including the compensation to be paid to company A, which means that the monopoly price that company A would normally charge basically disappears. The drug becomes sort of like a generic drug that you see now. It becomes much, much cheaper because there's effectively no longer a monopoly, right? Now, in addition to this, under the 2001 Doha Declaration, which is an amendment to the TRIPS agreement, which received final permanent approval in 2017, least developed countries, or LDCs, can import these compulsory licensed generics, right? So if you don't have the ability to make them yourself, you can import them from another country that has done compulsory licensing. And together, what these provisions do, at least in theory, right, is to potentially create a mechanism to distribute dramatically cheaper versions of patented drugs in health emergencies right now in the status quo without having to technically waive any intellectual property protection. Now, as you can imagine, this is potentially super important ground for the neg, as it potentially lets the negative argue that we do not need to reduce intellectual property protections, that under the current law governing intellectual property protections, there is a mechanism to allow these drugs to be distributed in an affordable way. There's a really nice FAQ from the World Trade Organization on how this works that we will link to. And as we'll see later, the negative may argue that this system in the status quo already takes care of all of our drug IP issues, and that consequently we don't need to waive IP protections. That brings us to question 4 out of 5. Why specifically are we talking about this issue right now? Well, as we said earlier, because of COVID. Essentially, developing countries are asking the World Trade Organization and its members to waive patent protections for COVID vaccines and treatments, to declare them totally null and void, at least temporarily, to make them more easily available in developing countries. Specifically, in October of 2020, India and South Africa petitioned the WTO to waive the requirements under the TRIPS agreement that countries enforce their IP protections with respect to vaccines and drugs related to COVID. This request was made in a very specific document, right? And we're going to link to the actual petition that they filed, and we do recommend that you read it, but it reads in part, in these exceptional circumstances, we request that the Council for TRIPS recommend as early as possible to the General Council a waiver from implementation, application, enforcement of sections 1, 4, 5, and 7 of Part 2 of the TRIPS agreement in relation to prevention, containment, or treatment of COVID-19. The waiver should continue until widespread vaccination is in place globally and the majority of the world's population has developed immunity, right? This is not the first time the possibility of waiving IP protections nations has come up before the WTO. In the late 1990s, there were calls for wealthy nations to waive patents on HIV/AIDS treatments. And while a full waiver never happened, it did lead to an amendment of the TRIPS agreement, which we talked about earlier, which was the Doha Declaration. Anyway, it gets a little complicated, but if you fast forward to the present day, on May 5th of 2021, the United States announced it would support the waiver of patent protection for COVID-19 vaccines. Many other large countries, particularly in the EU, are opposing this, at least for the time being. Now, you might ask yourself, exactly how would this waiver work, right? Well, this is very important. It would work like this. The members of the WTO could collectively decide to waive the TRIPS agreement provisions that require IP protections. But it is extremely hard to do this since under WTO rules, waiver of any provision of the TRIPS agreement has to be unanimous. That is, all 164 countries have to support it and any one country can block it. And just FYI, not surprisingly, the latest news on the state of these discussions and negotiations is that they stalled in late July, according to the National Law Review on August 24th. But this is the core proposal. WTO member nations unanimously agree to waive the provisions of the TRIPS agreement as they apply to COVID treatments and vaccine. And that is the core proposal being debated here. And I think, as we'll discuss at length in just a minute in the definition section, this appears to me to be the only truly topical case that you can run. But I'll explain why that's the case in just a second. So that actually leads to question 5. Is there a non-COVID specific angle to this resolution? I bring this up briefly because remember, the resolution doesn't specifically say that we are talking about COVID treatments. It just says medicines. And I wrestled with this question of could you run a case that's not about COVID for a day and a half as I tried to write this video. And as I mentioned earlier, it really made me wish that the NSDA had been more clear in its drafting. But I ultimately came down on the side of concluding that non-COVID related general reforms to patent laws probably are not topical. And as I said, I'm going to talk about why that's the case in a second in the definition segment. But to be fair, there certainly are well-researched ongoing policy debates about the general scope of IP protections for drugs and medical devices that exist completely separate from this specific issue of COVID vaccines. For example, there are many economists and other authors who argue against loopholes and technicalities in the patent laws that allow pharmaceutical companies to extend the life of their patents well beyond the 20 years that serves as the baseline. These practices are called things like evergreening and thickening, and they basically seek to delay the time when other manufacturers can make a generic version of your drug. The bottom line is there are lots of really good economic arguments against these, but I don't think these advocacies or plans are topical for reasons that I'm going to get into in just a second in the definition section. But I mention them because given the vague wording of the resolution, it is not an obvious 100% ironclad lock that they could never be topical. I don't think they are, as I'll explain in a minute, and for that reason I wouldn't run them, and I'm not going to show you how to run them. But you should just be aware, because of the weird wording of this resolution, it is possible that you could see someone coming in with a non-COVID specific case, and you will need to be prepared for what happens if they do, and we will definitely talk about that. So on that note, at long last, let's move on and talk a little bit about definitions and framing. All right, let's do some definitions and framework. Again, moving efficiently because there is so much to cover. We'll start with the phrase, the member nations of the WTO. So who are the member nations of the World Trade Organization? Well, as noted earlier, we're talking about 164 countries out of the 195 countries in the world, ranging from wealthy superpowers like the US, Germany, and China to smaller countries like Nepal and Estonia. There are also 25 non-member observer countries like Belarus, Iraq, and Iran. And the only non-members are basically tiny island nations and weirdo countries like North Korea. There are a total of just 14 of those. Now, the most important definitional issue I see is the very first word of the resolution, which is the article "the." "The" modifies the phrase member nations of the WTO. Now, as we know, if you've done debate for a while, different articles like "a," "and," and "the," and other modifiers like "some," "most," or "all" in a resolution help tell us how many and which ones of something, how many and which ones of a plural noun that we're referring to, right? So if we said a member nation of the WTO, that would mean one member. And if we said some members of the WTO, that would refer to more than one, but not all. But "the" is what we call the definite article, right? We use it only when we're talking about an object or a group of objects that we can identify with certainty. And there is exactly one identifiable group of nations in the world that we refer to as the member nations of the WTO, and that is all 164 member countries. If I said the United States States, China, and Chile are the member countries of the WTO. That would be incorrect, because while those are some of the countries that make up the WTO, it is not the one and only 164 member list of countries that comprise the group of members. Put another way, to keep it kind of simple, if on an exam the question were list the members of the WTO and you answered with 3 or 10 or 50 countries, even if they were all WTO members, that answer would be wrong, because those are not the members, they're just some of the members, right? So there's a strong argument that by using the definite article, the word the resolution strongly implies that the actor in this debate has to be the entire membership, all of the member nations of the WTO. They all have to do something and play some role in whatever action the AF is advocating for. And that makes sense as a matter of just sort of common sense as well. Like, why would the framers of the resolution make reference to this oddly specific, legally defined group of countries if all they really meant to say was just some countries, just whichever ones you pick? That doesn't make sense. They did it for a reason, right? And here's why it really matters. Remember, we said that the topic doesn't overtly specify which medicines we're talking about and what reductions in IP protection the AF can advocate. It seems like the NSDA subjectively meant to talk about a COVID patent waiver because of the timing and things like that, but it doesn't explicitly say that. But the use of the word "the" helps narrow things back, and I think bring the debate back and redirect it toward the COVID patent waiver, and let me explain why. So imagine an affirmative comes in and advocates for repealing national level intellectual property laws that allow for practices like, say, evergreening. Okay, so evergreening is this very unpopular practice by which you extend a drug patent by filing all sorts of tiny little sub-patents. It's very unpopular. If you could run a topical AF case against it, you would love to, because there's tons of literature opposing it. But could you run that case? Could you say, hey, the resolution didn't specify COVID drugs, I'm just going to pick whatever I want and do a case about repealing evergreening laws as applied to all drugs, right? If you accept that "the" means all member nations of the WTO, then my position would be no, you can't. That case would not be topical. Why? Because not all member nations of the WTO can do it. Right? Not all member nations of the WTO have laws that allow for evergreening. In fact, as we'll talk about in just a second when we get to the definition of intellectual property protections, some WTO member nations have no IP protections for drugs at all, or essentially no protections at least. And since these 164 countries all have different drug IP laws, and some have none at all, there really is no domestic intellectual property reform or reduction that they all can do, whether it's evergreening or thicketing is another practice, or just like reducing patent length, whatever you want to talk about, they can't all do it together, right? Because their laws are all different, and some of them have no drug patent protections to reduce in the first place. The only thing that all the members of the WTO can realistically do to reduce drug IP protections is the one thing that they all have equal control over, which is unanimously agreeing to waive the drug patent requirements of the TRIPS agreement with respect to COVID treatments and vaccines. So if an AF comes in running any sort of weirdo, domestic reform on patent laws or anything like that, I am immediately going to pull out a topicality block that says, number one, it makes the argument for why "the" means that the actor must be all member nations. Number two, whatever domestic change you're proposing, thicketing, evergreening, whatever it is, right, is not something that all the member nations can do because their laws are all different and some have no drug IP laws at all. And thus, three, you are not topical because you are addressing the wrong actor, and thus the negative wins, right? And we'll link to some sources that explain some of the factual points you'll need to make this. First, for example, that least developed countries are in fact exempt from drug patents, and the fact that some of these countries do not have any drug patent laws, like Angola, Madagascar, Liberia, Rwanda, and Uganda, right? Anyway, I think the NSDA could have been a lot more clear and explicit about this, and you wouldn't have to work through this convoluted logic, but hopefully I've done it for you. And hopefully I've persuaded you that you really do need to focus on the COVID waiver rather than going off onto some other approach to the topic. But whether I have or not, let's move on to the next phrase, which is reduce. Reduce, according to Webster, is to diminish in size, amount, extent, or number. So there's a little bit of a question about whether waiving the TRIPS patent agreement for COVID vaccines meets the definition of reducing. I think it clearly does, but let's briefly explain why. If you reduce something down to zero, and that's what a waiver would do, right? It would reduce the amount of protection for COVID drugs down to zero. You have still reduced it, right? That may not be the term that we would use in common conversation, right? We might say eliminated, right? But it is still technically correct that you have reduced it. So if I, outlaw fast food restaurants in my town, well, I'm going to reduce the number of fast food restaurants in my town down to zero. So I think it is clearly topical, but it's just worth briefly mentioning why, right? The next phrase in the resolution would be intellectual property protections for medicines. Now, remember that all substantive intellectual property protection comes from the national level, not from international organizations. So it would be totally impossible, certainly in a 40-minute LD round, but also in this video, to even begin to sum up all the different details and permutations of IP protections. But WTO's TRIPS agreement does require member nations to implement domestic laws that provide certain basic levels of intellectual property protection, including patent protection, which includes drug patent protections with major exceptions, right? And there's a very good summary of how this works on the WTO website that we'll link to. But here again, the basic takeaway is pretty simple. You've got 164 sets of different intellectual property laws, including some countries that don't have any at all. There's literally no practical way in the course of a Lincoln Douglas debate round we could even begin to discuss what they all are. There is no way that all WTO members could all take any particular domestic reform that you might propose. The one thing that they can do together, right, is to procedurally waive the requirements of the TRIPS agreement. Not to be redundant, but I think that's just worth mentioning one more time. The last definitional point that I have is about the term medicines. And there is one question that I've seen raised by some other folks, which is, are vaccines medicines? Because there are some definitions of the word medicine that imply that it only refers to something that treats an existing illness. So for example, Webster refers to medicine as a substance or preparation used in treating disease. But there are broader definitions. For example, the Cambridge Dictionary defines medicine as treatment for illness or injury or the study of this. And if you note in the image we've got up on the screen, it also points to preventative medicine as an example of a form of medicine. And I think the common sense argument would be, well, if there's any such thing as preventative medicine, if you believe that that is a thing that exists, then certainly vaccines must be considered a form of medicine because they're sort of the ultimate form of prevention. Also, even if you don't believe that, you can still argue that COVID vaccines are readily capable of treating an illness in addition to preventing it, because there's a ton of evidence out there right now that COVID vaccines, even when they don't prevent people from contracting the Delta variant, right, they still are dramatically reducing the symptoms and the severity of that variant, right? So for millions of people, vaccines are not total prevention from ever contracting the coronavirus, but instead they are a treatment that reduces the severity of a disease. So I thought that was worth addressing in case you get somebody who wants to fight over whether vaccines are topical. Lastly, in terms of framing, I just want to briefly talk about values and criteria. I'm not going to spend a ton of time on this just because of the length of the video, but I will say that intellectual property is by its nature a sort of utilitarian focused issue, right? We give people and we give companies these temporary exclusive rights to their inventions, not because we think it's inherently good or right or moral that they have them, but because we believe this will incentivize inventors going forward to create useful new things, right? Drug company A gets a patent on a cancer drug, it makes $1 billion. Drug company B says, well, heck, we're going to go research an even better cancer drug. A talented college student decides, I'm going to go into drug research so I can make a lot of money, right? So while there are a lot of values you can run here, the value of life, the value of morality, things like that, I really do think as a practical matter, most rounds are going to come back to a utilitarian analysis of which rule, waiving the patent rights or not waiving the patent rights, is going to save the most lives and improve the quality of life the most. Now, I'll say, if you judge a fair number of LD rounds, you find that utilitarianism as a criterion or a value standard often gets attacked on the grounds, that it can justify doing terrible things, or it can dehumanize people or treat them as a means to an end, right? And I think that it's worth just really quickly in this video noting that there are a lot of solid responses to these criticisms. But the first one and the most basic one, and I think it's worth mentioning, is that 90% of the time, when people in LD criticize utilitarian standards, they themselves are also running a form of utilitarianism. They're just not admitting it, right? So for example, if you run into an app who says their value is morality and their criterion is protecting human life, right? And they criticize you, for running a utilitarian analysis on the negative. Well, the most simple question to ask them is, oh, okay, so you're valuing human life. how do we measure whether we're protecting human life? And the answer almost always boils down to, well, we have to look at the evidence about, the AF world versus the neg world and look at which one saves the most human lives. Well, guess what? If you say that, if like you're counting up the number of lives being saved, no matter how holy or wonderful you think human life is, you are a utilitarian. That is utilitarianism. It may be utilitarianism that's narrowly focused on one kind of benefit, like keeping people alive, but it is still utilitarianism because it measures the rightness of the action by the results it produces. If you measure the rightness of an action by the results it produces, you are a utilitarian. The only way you're not running some form of utilitarianism is if you're willing to point to like a specific type of action that is not defined by its results and stand by the idea that this action is always good regardless of what outcome it produces. So if you say, I want to waive patent rights because life is more important than money, life should always come first, and I think waiving patent rights will save lives, great, you're a utilitarian. The only way you would not be a utilitarian is if you said, I want to waive patent rights because that is somehow an intrinsically morally right thing to do, regardless of the outcome. So even if waiving patent rights would end up killing millions of people in the long run, I'm still for it because it's inherently right. Anyway, that's just my little digression of how when I judge LD debate, I frequently see people fighting over whether you can run utilitarianism and not realizing that really both sides in the debate are actually running utilitarianism because at the end of the day, they are appealing to the outcome. And if you are appealing to the outcome, you are just as utilitarian as the other person in the round. So anyway, that's my little soapbox. Now let's get to the part of the video that you've all been waiting for, which is our analysis of the affirmative followed by the negative. Okay, so let's get started with the affirmative arguments. I'm going to spend a bunch of time talking about policy and economics and specifics in just a second. So before we get into that, let's go in a slightly different direction and start with the first argument, which is going to be waiving IP protections on COVID treatments is an ethical imperative, right? Now, as I said, we're going to have to spend a bunch of time for the rest of this video talking about policy and economics and other very practical stuff. So before diving into that, there's this very nifty piece from Jecker and Atweer that breaks down the ethical and moral arguments about an IP waiver for COVID vaccines. It's not a bunch of extensive data. It's not a bunch of complex international relations stuff. It's just kind of the philosophy of why a waiver is morally mandatory. And it is conveniently divided up into consequentialist and deontological arguments, which is really neat for LD, as well as other nifty arguments like this one on global solidarity, talking about why, it encourages global solidarity to address the problem of the COVID pandemic together as one, rather than having individual nations sort of fight over intellectual property. So check it out. It's a very nice, concise, LD-friendly source. In addition to that, on sort of the just general ethical level, there's this very nice statement from human rights experts that was published by the UN, which asserts that, some kind of action to share COVID-related intellectual property is sort of a human rights imperative. So to start out on a more sort of Lincoln Douglas focused ethical note, there you go. Now, let's do what we have to do, which is dive into what is necessarily an empirically dense policy and economics driven analysis. So the second point will be there's a shortfall of vaccines currently being manufactured by patent holders. This is sort of like your policy debate, what we call inherency argument. There's an inherent problem in the status quo that needs to be fixed, right? So the first point is, how much of the vaccine do we need to solve the problem? Well, this is from Duclef with NPR in August of 2021. The estimate is that we need 11 billion doses to bring the pandemic under control. This article also has some good points about how the immunization rate in low-income countries is extremely low, like 5% of the population. So it's a handy piece to have to just sort of talk about how big the problem is and how the status quo isn't working. The journal Nature, their editorial board in May 2021, talks about like what the status quo actually looks like and tells us that, unfortunately, even though we need about 11 billion doses, we're only likely to see about 6 billion doses produced under the current status quo, with most of those going to rich countries. So as you can see, in a paper published on May 19th, a report that the industry is likely to have produced around 6 billion doses by the end of 2021. The number of vaccines given so far in Africa amounted to a little more than 1 dose per person for some 2% of Africa's 1.2 billion people. This is among other factors, because the continent currently imports 99% of its vaccines, and because African countries lack the pre-order purchasing capacity of richer nations. The problem arguably is going to get worse due to booster shots. As you know, now in the United States and in Europe, we are debating about whether people need to get a third shot because the power of the vaccine wanes over time. So this is from Ahmad Touaj in August of 2021, and it talks about how again, the use of booster shots is going to keep skewing the number of vaccines that go to rich countries and keep them away from developing countries, because rich countries can pay more and can make better deals. So really what all of these points do, together is point out that we are, in a situation where the status quo is unacceptable. We're not getting enough vaccines to enough people. Now, hopefully, for most debaters, they will accept the premise that vaccines are necessary. They're saving lives. You won't have to necessarily link it to deaths. But if you do, if you've got a debater that wants you to link to a terminal impact of vaccine shortfalls by, for example, linking to preventable deaths, there's this very good piece from Galvani and others from the Commonwealth Fund in July of 2021. And as you can see here, it talks about in the United States, based on statistical models, what the death toll would have looked like with no vaccination and with less vaccination. So if you look at the middle bullet point, what you'll see is that the U.S. had achieved only half the actual pace of vaccination. And we're over 50%. So let's say we were down at like 25%. You would have seen over the course of just a few months in 2021, 121,000 additional deaths and more than 450,000 additional hospitalizations. And of course, you can extrapolate this, right? You can point out that this is just the United States, which has a relatively strong emergency healthcare system, and you can extrapolate, say, the 121,000 deaths at half the vaccination rate. Well, if you extrapolate that from a population of 330 million in the US across 7 billion people, many of whom are in countries with very poor emergency healthcare, you're going to start to see that there will easily be millions of preventable deaths from the lack of adequate vaccine supply. So this is sort of your inherency argument. This is where you make the case, however you choose to do it, to the judge that the status quo is not working and people are going to die as a result. I think there has to be something like this in just about every affirmative case, however you choose to structure it. So in addition to having what we would call in policy debate the inherency argument, which is there's a problem, we also have to have what we would call the solvency argument, which is that a patent waiver from the WTO member nations will solve, or at least begin to solve, the problem. So the first thing you can do under this is just point out, obviously, that more vaccine supply saves lives. So you can refer right back to the card we just looked at from Galvani and the Commonwealth Fund, explaining that even in the U.S. alone, a reduction in vaccine supply would lead to hundreds of thousands of preventable deaths, and you can extrapolate across the world. Without vaccines, we're going to see millions of preventable deaths, right? But we can show that WTO member nations waiving the IP requirements of the TRIPS agreement will lead to, greater supply. Can we do that? Well, it's less obvious, but there is some decent evidence to support it, and obviously this is pretty important to any AF case, right? So the best place to go on this, Human Rights Watch in June 2021 has this really good piece laying out a bunch of arguments about why the TRIPS waiver is necessary to facilitate adequate vaccine supply. It cites to other studies, it answers common criticisms, it divides up its arguments into these neatly numbered sections. I would say this is arguably the second best AF source I found in all of my research. I'll talk about what the best one is in just a second, but really just reading this and reading the sources it links to, you can cut a dozen great block cards from this article, including cards about why statistically, if you don't have a waiver, it is unlikely, no matter what else you do, you will be able to have adequate vaccine supply. In addition to that, if you want to argue that waiver is necessary, there's a piece from Bonri Ito. This is from August in 2021. It's in Vox about how there's precedent for a waiver of IP rights working. And it talks about, among past cases, we should look at the application of the waiver of the WTO TRIPS agreement to drugs that treat HIV/AIDS in 2001, according to an estimate by Médecins Sans Frontières, which is Doctors Without Borders. That's just the French name for it. The prices of patented drugs dropped to less than a tenth of the previous level in 1 year, improving access to drugs around the world. Given that the principle of competition works, access to COVID-19 vaccines is expected to improve, right? Another point that you ought to make is that your burden as the AF is not to show that an IP waiver by itself would be enough to solve the entire problem. Instead, you should argue that the IP waiver is one ingredient in a larger solution, and that if you don't do it, the solution can't work. In other words, it's sort of a try or die argument, right? If we don't do this, then all of our other efforts will fail, right? And so there's a piece from Irfani and others in May 2021 that talks about how, essentially to unleash the full impact of an IP waiver, governments and companies must offer technology transfers, share know-how, provide logistical support. Previous examples illustrate the illusion of just waiving intellectual property, right? And basically what this talks about is how, look, I will admit to you, you should be candid. I'm not going to lie to you and tell you that all we have to do is waive intellectual property and the solution, will be automatic. We do have to then help these developing countries, these companies in places like South Africa and India. They want to ramp up production of generics, right? We've waived the IP protection, so now they can legally produce these generic drugs. We have to begin sharing technology with them, sending experts over, helping them ramp up production. I absolutely agree with that, Judge. But if we don't waive the intellectual properties in the first place, they won't be able to do that at all because they'll be legally prohibited from doing it, right? Another point is that, timing, the argument would be, well, it's going to take time to do this, right? It's going to take a long time. But the response to that would be, even if the ramp up to producing these vaccines in countries like India and South Africa takes time, remember, we're going to have COVID variants with us for many, many years. The consensus is that we're going to have to sort of treat COVID vaccines like flu shots and get them renewed and sort of get boosters, every year or so, or every 6 months maybe, right? So, according to Irfani in another section of the same article, in many cases, manufacturing capacity needs only repurposing, which will take mere months, and COVID-19 will be a threat for years. So you can just point out that, even if the negative makes you think that this will take like a year to get this production ramped up, well, guess what? COVID will be with us in a year. It'll be with us in 2 years and 3 years. It's probably going to be a perennial disease like the flu. And if we want to save lives over time, we need to have production capacity in places like India and South Africa and other places. Now, we know in advance that one thing the negative is going to try to argue is that, as we spoke about this earlier when we were talking about the sort of background, is that there are mechanisms in the status quo to solve the problem and that you don't need to reduce IP protections and you don't need a waiver. So another point that I'm going to make on the app, and I think this is an important preemptive point, is that status quo options like compulsory licensing are too slow and complex to solve the problem, right? And the argument here would be that the current exceptions and exemptions that exist under the TRIPS agreement, like, for example, getting a compulsory license, are far too case specific and far too procedurally difficult to be able to effectively solve the shortfall of COVID vaccines in a sufficient amount of time to save these lives, right? You as the AF need to argue that it is urgent that we start acting now. And there's a couple of sources that let you make this argument. I'm not going to spend a lot of time talking about the technical reasons why compulsory licenses are slow. The first source comes from Doctors Without Borders in May 2021, and it has just a nice summary of how compulsory licenses are at a case-by-case approach, right? So this is the basic difference. Like, if you do the compulsory licensing approach, that means that every country that wants to produce vaccines generically has to go to every company that they want to be, or at least every country in which companies exist, that they want to be able to use their IP, and they have to negotiate a specific agreement. And so by the time you get all of these specific agreements done, right, it's going to take months, if not many, many months, if not years, right? So that's the basic argument, that you would rather have a blanket waiver across the board, which, by the way, you can point out to the judge that in the real world, it might take a long time to get this blanket waiver. But remember, Judge, you have fiat power, right? You can, as soon as you sign your ballot in the theoretical world of debate, the COVID IP waiver is in place. They can literally start manufacturing this stuff tomorrow. Now, that might not be realistic, but debate is an educational activity, and part of the conceit that we have is that you as the judge can sign your ballot to make this happen. You can't do that with compulsory licensing, right? Compulsory licensing takes how long it takes. So again, the Doctors Without Borders piece is good. If you want a more complex piece, there is this one from Thambasetti and others, I probably pronounced that wrong, in June of 2021, and it sort of lists 6 different objections to compulsory licensing. And if you get somebody coming in who is really going all in on how compulsory licensing means that the status quo solves, this is a great card that lists all 6 of them in a row. I mean, I wouldn't necessarily read it, but you could summarize it, right? You could go and say, look, There's 6 problems with that. And I'm not going to go through what all of them are, but it's a nifty card that lets you sort of overwhelmingly hit back on the idea that the status quo solves the problem, right? Now, the next point is that the patent waiver is not going to hurt pharmaceutical companies' future incentives. Remember, the core economic argument that the negative is going to make is that if we take away a patent, it might be great right now. Like, we take away the patent and we can make the drug, the currently existing vaccines and treatments, we can make them cheap for everybody. But the future precedent is dangerous, right? We take away these patents and these pharmaceutical companies say, oh my gosh, well, if they're going to do that to me, the next time there's a pandemic or the next time I want to manufacture a drug, I'm just not going to bother. I'm not going to do the research because they'll just strip it away from me, right? And that is the main sort of economic reason that sort of business interests and the pharmaceutical companies themselves cite against waiving the patent, right? So the question is, has that actually happened? Is that empirically happening in the status quo? And the answer is, if you look at the real world, no, right? The opposite is happening, right? So first of all, COVID vaccine patent holders are already set to make billions and billions of dollars in profit, whether you take away their patents or not. And this is from Jared Hopkins in the Wall Street Journal in May of 2021. And he's just talking about the amounts of money, that the different manufacturers have made from COVID vaccines. And you can see some of the numbers here. The real money quote is that Pfizer said it expects about $26 billion in COVID-19 vaccine sales this year, while Moderna forecasts $19.2 billion based on purchase agreements. And remember that these companies, as we'll talk about, are not out like trying to sell their vaccines door to door in some risky market. They've had their stock preemptively bought up by governments around the world. They have billions of dollars in profit already locked in. Even if you were to take these patents away forever tomorrow, they have already made massive, massive profits that would clearly justify any future investment, right? And this is proven empirically by what happened to the stock prices of these companies when the United States announced its support for an IP waiver back in May. The stock prices moved very little and it bounced back up, right? So this article from Rich Mendez of CNBC talks about how you saw a small decline in stock prices of like 5% or 12% for these companies when the US announced its support for a waiver, but then they rebounded and they have been soaring and rising higher and higher throughout all of 2021. So the year to date, and I just looked these stock prices up. You can do that. You can just Google stock prices year to date, right? Pfizer is up 26.6% so far in 2021, meaning it's added a quarter of the entire value of its company, right? Even though the US announced in May that it supports this waiver, Pfizer is still up dramatically, right? Moderna is up about 280% so far in 2021. In other words, it's almost quadrupled the value of its company, right? So overall, Pfizer, Moderna, AstraZeneca, they're set to make $11 billion, $6 billion, and $1.2 billion on COVID vaccines in 2021 alone. These are net profits, right? This is according to The Guardian in August of 2021. So in short, even if every single one of these patents were waived and all of the COVID vaccines went generic, say realistically by the last couple of months of 2021, these companies have already made billions, right? Even if they never made another dime off these vaccines, they are already immensely profitable. They've made huge amounts of money for these companies and driven their stock way up. So if you're a drug company, let's think about what the future precedent is here, right? What precedent is this setting for future incentives? Well, let's imagine you're looking at this situation in terms of your incentives and what they should be for the future. Like, should we invest in a vaccine for the next pandemic? Well, the answer is we've already made billions of dollars in profit, right? In a locked-in purchase from these governments. So the rational incentive is, yes, we should invest in vaccines next time, because even if they do take away our patents after like a year or two or whatever, we're still going to make billions of dollars in profit. In other words, the thing that you can say to the judge is, look, they've already made billions of dollars and they would do it again in a heartbeat, even if they knew that after a little while they'd lose their patent. Even if they knew they couldn't keep making billions forever, they're still going to take the deal and make vaccines the next time a pandemic comes around because they know they can make billions of dollars, right? And that actually dovetails nicely with our next argument, which is that a waiver of intellectual property is fair because governments have invested billions and billions of dollars in these vaccines, right? So there are basically sort of two arguments here for the affirmative. First, morally, patent owners have an extremely weak property claim to exclusive control of these vaccines because they did not exclusively produce them. They produced them with tens of billions of dollars in government investment. So if there was ever going to be a drug in the history of the world where a patent waiver was justified, it's this one. But secondly, not on the moral level, but on the more utilitarian basis, again, if we look forward to future incentives about what a waiver would create, the answer is it won't create any negative precedent for future drug development because this is an unprecedented case where the government has so heavily subsidized a product that it is effectively almost like a part owner, right? This isn't some antacid pill, right, that Johnson & Johnson, that's totally optional. Nobody necessarily needs it, but it's going to make $1 billion for Johnson & Johnson. It's more like a wartime effort. So it's almost like imagine World War II, the government investing billions of dollars into Ford to produce like tanks and Jeeps. And then Ford says, well, we own the patent on these things, so we're not going to make them for you or let you make them unless you pay our monopoly price. Well, guess what? In a war effort like that where the government had invested billions of dollars, you know what the answer would be? It would be, listen, son, that's not how this works. Okay, this isn't regular patent world. This isn't some automobile. This is war, and we're going to make those vehicles. Similarly, in this case, this isn't some random antacid pill that you invested in. This is something that we paid you to do, right? And this isn't a special, and we're going to take these things from you, and we have a moral right to do it, right? This is an especially strong argument when you pair it with the fact that vaccine makers have already gotten filthy rich, right? So the basic argument is governments around the world shared most of the burden of creating these vaccines. You companies have made more than your money back, right? And you're going to keep making more because you have signed contracts that go out several years on what was basically our government investment. We as taxpayers paid for it. You are in no position, pharma companies, to tell us that we cannot now take the patent and let poor countries start making vaccines. Now, the best single source on this when you want to talk about how much we've invested, this comes from Frank et al. In Health Affairs, but this is just a really good rundown of exactly how much money we have spent subsidizing the development. It talks about, estimates between 18 and $23 billion for certain aspects of it. And the article goes through point by point and talks about how much the US government has spent to get these vaccines made, but also how it basically removed all of the risk from the pharmaceutical companies, right? It took away all of the market risk. These companies could not have failed, right? Because we bought all of the drugs from them. And that answers a common negative point about how drug development is, it's so risky. We have to let drug makers soak up huge profits when a drug is a hit because the next one may be a flop, right? But here's the thing. There was no risk here. The government came to Pfizer and Johnson & Johnson and Moderna and AstraZeneca and said, look, as soon as these things are done, we want to buy out your entire supply and then as much more as you can possibly make. There was zero economic risk here for these companies, right? Assuming they could put together a viable vaccine, which they all did, it was sold out before it was even made, right? So in terms of setting a precedent, this is not a precedent for some regular acid reflux drug or even for a cancer drug. It's nothing like that. The only thing this is a precedent for is what drug makers should do in the next pandemic. And the answer is, if it's anything like this one, then what you're going to do is you're going to get a multi-billion-dollar contract up front, make billions in profit, see your stock price skyrocket, and then maybe after a year or so, worst case scenario, you may have your patent waived after you've already made a massive profit. So the answer to the argument that you would make about a bad precedent from the negative is, if this is setting some precedent, it's a great precedent for drug development. No drug maker in their right mind is ever going to turn down this amazing lucrative deal, right? Even if it ends tomorrow with a patent waiver, they've already made out like bandits on something where the government did most of the investing for them and then bought all of their product from them before it was even made. And there's a very good piece of this from Brink Lindsay with the Brookings Institute in June 2021 that explains why sort of the basic model of intellectual property doesn't really apply in a pandemic, right? The idea that we should just let you make money for 20 years, right? Because what we've done is we've effectively replaced that model, in this case in the pandemic, with more of a direct government procurement model. In other words, instead of sitting back and saying, hey, private sector, do whatever you want and hopefully it'll work out and you can make some profit. And what we said instead was we went directly to these companies and said, here's exactly what we need you to make. Here's when we need you to make it, and we're going to buy all of it from you. It is much more like the government buying all the Jeeps and tanks from Ford or from General Motors or whatever in World War II than it is just sort of like general capitalism, right? And so we have a right to get what we paid for, right? And if that involves a waiver to save people's lives in other countries, we have a moral and economic right to that, right? So those are the basic affirmative arguments. Again, I think there's some really nifty ones. So now let's move on and talk a little bit about the negative. Okay, so on the negative, I think the core narrative that the negative needs to have in most debates is the idea that we totally understand the impulse that we have on an emotional level to want to do something about the issue of vaccine access and treatment access for folks in less developed countries. We share that, right? We want to do the same thing. This is not a question about whether we do that. It's a question about how. Right, about what will be most effective and whether or not there are ways, either in the status quo or maybe through counter plans, to best accomplish that. And I think there are very strong arguments, frankly, on all of those levels, right? So on that note, talking about, sort of the status quo, the first argument I have in my notes is that WTO members already have the means to ensure vaccine access under the status quo, right? So we look again, as we talked about earlier, to Article 31 of the TRIPS agreement, which allows for compulsory licensing, right? And so this is from James Bacchus with the Cato Institute in December of 2020, and it just explains exactly how compulsory licenses can work, and it talks about how there's no real evidence that they can't be effective in this case. He talks about how all these ideas that they're going to be too slow and too logistically difficult are just speculation. Nobody has tried them, right? Nobody has exhausted them as a possibility, and until we do that, we can't say that they won't work, right? There's another point. This is all from Doctors Without Borders from May 2021. This is actually from the same piece that we cited earlier against compulsory licensing. But they have a couple of good points in here that talk about how there is precedent historically for compulsory licenses to work and to be effective and to work fairly quickly. So if you look at the card we have up on screen, this is talking about how compulsory licensing in 2017 in Malaysia was effective in getting out drugs for hepatitis C. It talks about how it's been done in the past with HIV/AIDS. So there is precedent in the real world for very quickly and effectively using compulsory licenses to get necessary drugs, in the course of some humanitarian disaster. So it actually has happened, right? So basically the argument you make from that piece is that this is not some super complex, logistically impossible tool that the AF would make it out to be. It has been used before, it has been used quickly and effectively, and it is currently being used in the status quo. And that's actually an interesting point that also comes from Doctors Without Borders. The piece also points out that many countries have already amended their laws to make compulsory licensing easier than ever before. And some countries, notably Hungary, Israel, and Russia, already have used compulsory licensing for COVID-19 treatment. So again, this is not some pie-in-the-sky, logistically impossible thing. It's something that's been used in the past for other global health emergencies, and it is currently being used for some COVID treatments. So, if the AF tells you it's impossible, I don't see how it can be impossible because it's literally being done right now with some, COVID treatments. So it's a decent response, and if they aren't prepared for it, they're going to have a hard time explaining that argument. Now, the next major point I have is that IP protections are not the cause of global vaccine shortfalls and will therefore not solve the problem. The basic argument here that you get from a lot of sources is that it's actually input shortages and other issues that are causing the bottleneck. And this is from Mannix, an author in the Sydney Morning Herald in May 2021, and it talks about how you have shortfalls in essentially the ingredients and the parts that you need to make these vaccines. So in Europe, as far as I know, there are just 3 pharmaceutical glass manufacturers, said Dr. Jürgen Linder, head of the Active Pharmaceutical Ingredient Manufacturers Association of Australia. They can't all of a sudden produce a few billion extra glass vials to fill vaccine. When you see how complex those facilities are, it takes a long time to increase production. Vaccines require hundreds of products to make. Pfizer's has more than 280 ingredients sourced from 86 sites in 19 countries. The shortage of specialized high-volume plastic bags has become critical. So this and other sources that we'll link to will talk about how it's not a matter of intellectual property that is stalling the production. It's a fact that we are trying to make something at a rate that it has really never been made before on incredibly short notice, right, to dramatically change the global supply chain. And in some cases, you see bottlenecks, and those are what's actually causing the shortage of supply, right? Also, the WTO itself notes that there are dozens of trade and other regulatory barriers apart from intellectual property barriers that are slowing down vaccine distributions. There's this very nice list from the WTO of bottlenecks that are slowing the vaccine rollout. This is from July 2021, and it lists dozens of different factors that are slowing the vaccine rollout, from export restrictions to regulatory approval. It does not list IP protections. So, you can pick your favorite barriers from this list and argue, look, even the WTO itself is arguing that it is mainly logistical, supply chain, regulatory issues that are slowing the rollout. It is not drug companies, hashing, people over the coals with respect to their intellectual property, right? A related point on this comes from Prashant Yadav at the Center for Global Development, pointing out that an IP waiver won't solve because the manufacturing capacity doesn't exist in most developing countries, right? And he says, to speed up vaccination rates around the world, especially in low and middle income countries, we need more global manufacturing capacity for all COVID-19 vaccine platforms. But exempting COVID-19 vaccines from intellectual property rights will not increase manufacturing capacity, and as a result will not improve equity or access. And the basic argument here that is made by a lot of industry groups, if you want to put it in simple terms, is like, to make a very complex vaccine, especially these mRNA vaccines that we're seeing from Moderna and others, you don't just have to have the recipe, you have to have a very complex kitchen, multi-billion-dollar kitchen, and many, many people who are, essentially the chefs, like highly trained workers and employees and technicians with technical expertise. And these countries simply don't have this, right? So, the idea that we're going to solve it by giving away the recipe, by giving away the intellectual property when the production capacity doesn't exist, gets the cart before the horse, right? Now, a really important point that I think has not been mentioned enough in some of the discussions that I've seen about this is that the intellectual property waiver is arguably unnecessary, as companies are already signaling and have in some cases already voluntarily waived their IP rights to vaccines. Moderna in October of 2020 issued a statement expressly stating that it would not enforce its IP rights to its vaccine, right? It said this: accordingly, while the pandemic continues, Moderna will not enforce our COVID-19 related patents against those making vaccines intended to combat the pandemic. Further, to eliminate any perceived IP barriers to vaccine development during the pandemic period, upon request, we are also willing to license our intellectual property for COVID-19 vaccines to others for the post-pandemic period. So in other words, Moderna is, one of the more successful vaccines. They've already told you, hey, you don't have to do anything with our IP rights. You don't have to do a waiver in the World Trade Organization or anything else. We're voluntarily waiving them. If you in India or South Africa or any other country can get to the point where you are ready to go and start making our vaccine, we will give it to you. They've already said that, right? AstraZeneca also has essentially made the same promise. This is from Peter Beaumont in The Guardian, again in November 2020, and it says the coronavirus vaccine produced by Oxford University and AstraZeneca will be available on a non-profit basis in perpetuity to low and middle income countries in the developing world. The details of arrangements to supply poorer countries came as AstraZeneca revealed the interim results of phase 3 trials, right? So voluntary waiver shows number one, that you don't need a forced IP waiver because, look, even if you only had one vaccine, that's enough, right? The Moderna vaccine has proven to be very effective. If Moderna is saying, I'm going to give you the recipe to make this and let you use it legally, which is what they are saying, you don't need 3 or 4 other vaccines to do that. You've already got an effective recipe, right? But in addition to showing that, this voluntary waiver also shows that forced IP waivers probably won't lead to an increase in production, right? Because the basic argument here is, look, if IP rights were the thing holding back vaccine production, then the problem should already be solved in the status quo, because Moderna and to a lesser extent AstraZeneca are already saying, you don't have to force us. We are voluntarily waiving our IP protections. If that were the problem, then we would already see, and by the way, they did this before the vaccine was available. They did this back in the fall of 2020. So if that was the problem, right, then we should already see producers in India and Paraguay, wherever, right, ramping up and making billions of doses of these things. And yet, as of now, it appears that no developing country drug producer is taking up these companies on their offer to make a generic Moderna or AstraZeneca vaccine, which is as close to a real-world lab experiment as you can do on whether a mandatory vaccine waiver will solve the shortfall. We've already done a vaccine waiver. It wasn't mandatory, it was voluntary, but we've already done it and it hasn't solved the shortfall. That should be game, set, match for the negative, right? In addition to that, this is from Damien Gard in May of 2021, and it says basically that in October, Moderna vowed not to enforce its COVID-19 related patents for the duration of the pandemic, opening the door for manufacturers that might want to copy its vaccine. But to date, it's unclear whether anyone has, despite the vaccine's demonstrated efficacy and worldwide demand for doses. That underscores the drug industry's case that patents are just one facet of a complex process of producing vaccines. There are currently no generic vaccines, primarily because there are hundreds of process steps involved in the manufacturing of vaccines and thousands of checkpoints for testing to assure quality and consistency in manufacturing. So one common sense take for the neg is, look, AF, the thing you want us to focus on, this WTO waiver, it would take months of cajoling and negotiating in the WTO to even potentially get 100% unanimous agreement of 164 countries. And all that is going to get you is this recipe, right, for how manufacturers in India and South Africa could make the vaccine. As we said earlier, you still have to build this super complex billion-dollar kitchen, the facilities, right? And you have to hire these incredibly skilled chefs, the technicians, right? And here's the real kicker. You already have the recipe. Moderna has already said you can use their IP for free. So instead of wasting more time negotiating and fighting in the WTO over a part of the equation, the IP, the intellectual property, the recipe, right, that has already been solved, right? Every minute you spend negotiating over that is completely wasted because we've already got that part. Instead of doing that, WTO members should instead be laser focused on other things like technology transfer to get these, or just direct payments like subsidies, transfer funding, whatever, to get these developing countries the equipment and the expertise and the money they need to actually build the manufacturing facilities. The IP is not the problem, and concurrently, it is not the solution, right? In addition to that, voluntary waiver means the negative does not have to wait for compulsory licensing, right? So if the affirmative wants to come in and read all these very good cards, and they are good cards, right? For example, the Doctors Without Borders card is excellent about why compulsory licensing will take too long and it is too inefficient and you can't do it in time to solve the pandemic. The response that the negative has, that's fine with us, right? We don't have to do a compulsory licensing process because, again, we've got one, maybe two vaccines, depending on how you read the AstraZeneca statement, right? But definitely one very good vaccine that has already done essentially a license. They said, we'll license it to anybody, right? We don't need to waive it. So at this point, the waiver is really just theater. It's pointless, right? I mean, that's the argument that the negative would make, right? Additionally, on sort of a related note, we note that manufacturers are already cutting prices dramatically for developing countries. This just reinforces the idea that even in the status quo, without any waiver, these companies are already dramatically cutting the prices that they're charging to developing countries. This is from Jared Hopkins in the Wall Street Journal, and he says Bernstein estimates that Pfizer and BioNTech charge between $18 and $19.50 a dose in developed markets compared to $7.50 in developing markets, so about a little more than a third of the price. Moderna charges between $17 and $20 a dose compared with $8 in developing markets, according to Bernstein. So again, these companies are already pulling out all the stops to either give away their IP or at least cut the best possible deal they can for these developing countries. The problem is not them, right? That's the basic argument that the negative makes. The problem is these countries don't have the capacity to make this stuff yet, and the supply chain is backed up because the parts that essentially go into a vaccine are too hard to find, right? So if you want to, that is really good defense, right? That's defense that's so good that it's almost offense because it argues that this is just a complete waste of time, right? But if you want to generate some offense, there's a few different ways to do it. One is the idea that patent waivers set a dangerous precedent for stripping intellectual property rights, which endangers research and development for the next major health crisis. Right. So first, from James Bacchus at the Cato Institute in December 2020, we have this piece that talks about sort of how the general incentive structure of intellectual property is undermined by the waiver, right? And he just says, the primary justification for granting and protecting IP rights is their incentives for innovation, which is the main source of long-term economic growth and enhancements in the quality of life. And he talks about how when you strip those away, you strip away the basic incentive. So if you need a basic source about how IP works, this is a good piece from James Bacchus. The next point is that stripping IP rights through a waiver undermines predictability and reliability of patent law, which jeopardizes future COVID and other research investments. So this is from Myron and Suarez in May of 2021. And it just talks about how these pharmaceutical companies, they didn't invest all the money, but they invested a lot, and they have created a public good, right? Or a good, it's something that is valuable to the public that is far, far in excess of the amount of money that they're making. He talks about, they talk about how the global benefit of these vaccines is something like $17.4 trillion. Or $5,800 per dose. The amount of money that they're charging is dramatically lower than that. You can look at, for example, Johnson & Johnson and these other companies, Pfizer, and say, oh, they're making billions of dollars. Yes, they are, but that is a tiny fraction of the overall benefit to the world that these vaccines are causing. They're profiting to the tune of billions. The amount of good that their product is doing is in the tune of trillions, right? It's letting people stay alive, go back to work, economies can recover, trillions of dollars in benefits. So they're not making out like bandits. They are, in fact, only recovering a tiny fraction of the value that they have helped produce for the world. Another point on this that I thought was kind of interesting, this is from Gianna Gancia, who I believe is a member of the EU Parliament, and this is from May of 2021. And it's just talking about how you're going to destroy the incentive in future pandemics, right? Now, I realized earlier we made an argument against this, and frankly, I think that the counter argument we make is stronger, right? Which is that we've already basically paid them for their contribution here, billions and billions of dollars. They would do it again in a heartbeat. But this is a piece that basically says, look, what if in the near future an extremely effective anti-cancer drug was discovered by a pharmaceutical company, right? Well, would it have the incentive to research and try to develop that if it believed that, oh, well, if it's a serious health issue, and cancer certainly is, the government might just come and take this away from me. It might strip it away from me. I don't have the incentive to research it. Do I personally buy that argument? No, but this is a decent little card that sort of lets you make that point if you want to, right? And then lastly, if you want to really try to amp up the impact, Melissa Brand, who is with the blog IP Watchdog, and this also is from May 2021, talks about how, if we're going to go down this road of when a private company solves a major global problem, they get their IP stripped away from them. Well, we're going to be in a real problem, not just in COVID world, but also, for example, she talks about how there's a lot of research going on now about how to solve problems of climate change, right? And how it's very easy to argue that if we will strip away your intellectual property to address COVID, then why wouldn't we strip away your intellectual property if you solve climate change, which here in the ex-ante state, right, where we are right now, creates a massive disincentive for any private company to do any significant amount of research that it thinks is going to solve a major public problem if the precedent signal we're sending is, if you solve a big problem, you will lose your intellectual property, right? And that is the offense, right? That's the idea that we're setting a bad precedent that's going to destroy innovation, not just on COVID, but also on other things going forward, right? And then another related potential kind of small offense point is that waiving IP protections risks diverting components to less efficient producers, right? So this is from Iakabuchi from BMJ in May 2021. And basically the argument here is that, the supply chain is extremely complex when it comes to making these vaccines, right? And if you strip away you can give everybody the intellectual property that you can make infinite copies of that. That's like the software, right? But if every little, sort of startup, not very sophisticated manufacturer in these tiny little countries now has the ability to make it, they're all going to start clamoring for the as we talked about earlier, very limited, ingredients, these highly technical components, these massive plastic bags, and of course the people with the expertise to do it, right? And those aren't going to increase. All that's going to happen is if instead of having 3 highly qualified, well-sourced factories making it, we now have 30, you're going to risk sending many of these ingredients and components to places that are slower, that are less efficient, that have less, safety protocols, that are less efficient at, ensuring a good quality product. You're going to kind of randomize who gets the inputs and arguably make the process even less efficient because people who don't know what they're doing with these parts are now getting their share of a limited universe of components and ingredients, right? Now, obviously, this point from Iakabuchi is from an industry association, so be aware of the bias there, right? But it's not a terrible point on a logical level, right? Another point, and to generate some, I don't know if this is offense or defense, but it's the idea that the IP waiver is too slow to help in the pandemic. So this is from Chowdhury at CNBC, and it basically just says that, Disha Biswal, president of the U.S.-India Business Council, agrees that a patent waiver won't address the question of boosting vaccine supplies to the rest of the world. With a patent waiver, it would take months or years before the technology, raw materials, and production capacity is up to the standard for countries to be able to produce their own vaccines. Instead, she says the focus should be on helping countries that are already producing vaccines scale up their production rather than just giving the instructions out to everybody. So these are all some pretty good points. At the end of the day, the basic argument that the negative makes is pretty simple, which is there are multiple ways to solve this problem in the status quo, and giving out this intellectual property to countries that are not prepared to do anything with it will not benefit anyone. It will not result in ramping up the supply. It will only sort of randomize who gets the ingredients and possibly slow the process down, right? So that's the basic gist of the negative. And with that, we'll come back in just a second for a few quick final thoughts. All right, so final thoughts, really quickly. My final thought on this resolution is one that I talk about a lot on this channel, which is that it's very important to be able to pull back the camera, right, and tell a simple story and a simple narrative about what you're advocating for. Some people call this a core theory, some people call it a narrative, whatever you want to call it, right? It's going beyond just the cards and the data in the case and being able to explain succinctly and clearly in plain English what you're saying on either side of the debate, right? This is especially important at the beginning of the year when you may have brand new judges, when you may have judges getting their feet back underneath them after not judging for a while, right? But when you're on the affirmative, right, being able to say, look, there is no reason not to remove this impediment of intellectual property from addressing this global pandemic and saving millions of lives. We're going to lose millions of lives if we can't roll this out. Intellectual property is a barrier. We are removing it. It is just and fair because this isn't a regular patent. This is something that the government essentially paid for anyway, and these companies have already made billions of dollars, so they are not going to have any perverse incentives. And so for those reasons, that's the story that the AF tells, right? On the negative side, the story is equally simple. There are better ways to do this that are built into the status quo, right? You don't have to do anything like this massive draconian step of waiving intellectual property and all the dangerous precedents that it sets in order to solve this problem that will only make the problem worse, right? So at the end of the day, you really want to make sure that in addition to all the details that you understand and the blocks you write, that you've got a simple story that you can tell. So anyway, we are back at it, whether you're going virtually or if you're lucky enough to be debating in person, which hopefully more of us will be throughout the year if we can get through this pandemic appropriately, right? But we're back at it, and that's a good feeling. So I hope you have a great start to your year. If you've got questions, you can drop them in the comments below. But as always, we hope you have a great experience on this topic. So with that, I'll leave you with our usual, which is remember, debate is for everybody. So work hard, have fun, and hail state.